first one brought up, obviously. The second is, it's just, all I can do to tell you is what I told you. You know, you got to make a choice. It'll suit me fine to write the checks to whoever these schools you want to designate, and that ends my process associated with it. But it certainly just begins the process for those principals and those other parties at those schools.
I think since we've got the new policies in place, it just needs to go through just fine. Listen, let me ask you a question. Before we started this list, we had about 370 left in our capital outlay, is that right?
That's correct.
And we added about 40 on the
That's correct.
demolition of the Campbell. So it's going to leave us with still about 328,000.
That's correct. Unfortunately, I have projected 370 in the budget instrument in front of me, but that's okay. The world's round, we'll get there.
Okay. All right. We have a motion to approve the capital outlay project.
Oh, one more thing before we go any further. I have one more question. Are you guys going to try to do this before 6:30 or not, and be getting ready to run the train off the tracks if you say yes to that question? Because we have a purchase order deadline coming up on June the 15th. So today's May the 10th. It's very unlikely that you would have, unless you've got specifications waiting this second in order to drop the hammer on. Now, it doesn't bother me because I've already carried the funds forward and reappropriated them, and they can be done in July just as easy as they can in June. It just takes time in order to carry it out. We can do as many as we can, but again, we won't be able to do them all.
All right, we have the bathrooms. Do I have a motion to carry forward? Second.
Second.
Let's vote on the motion to carry forward first.
First, Mr. Chairman,
Yeah.
I didn't spring anything on you, Mr. Byrd.
Well,
That was passed through Finance Committee last Tuesday. If you've been there, you've seen it.
I wasn't here, so I didn't know.
Okay.
Okay, call the roll. Voting on carry forward.
Miller,
Yes.
Lynch,
Yes.
Rutherford,
Yes.
Parker,
Yes.
Bird,
Yes.
Hill,
Yes.
Lawson,
Yes.
Creekmore,
Yes.
Collins, Ford.
Yes.
Motion carries.
All right, now we're voting on the approved capital outlay project. We have a motion.
I saw both.
We have a second.
Second.
Any discussion?
Mr. Chairman, now this, when we vote on this, Campbell County and Jellicoe, this is to go through the.
Yes, both.
Do you know if they have a list
I'm sure he does. He's,
that they're ready, or will be ready for this $5,000 since it was?
well, sure, but I'd say he's got a pretty long laundry list of stuff he wants and needs.
If it'd be possible, Jeff, since this is coming through your office, if we could get a list of, maybe that way we know, that way.
I will make sure that tomorrow we begin to get said list and work with the parts to refine said purchases.
All right, any other discussion? Call the roll.
Miller,
Yes.
Lynch,
Yes.
Rutherford,
Yes.
Parker,
Yes.
Bird,
Yes.
Hill,
Yes.
Lawson,
Yes.
Creekmore,
Yes.
Collins, Ford.
Yes.
Motion carries.
Next item 6, items for discussion. Not any, we'll go to legal matters.
Mr. Chairman, I have 3 items. The first one is good news in your EFC federal case. We received approval this week to enter into a mediation which will occur on June the 20th. We were able to select Pam Reeves as our mediator. Your attendance is obviously not required, but any board member that wants to attend the mediation will be allowed to attend. They're usually pretty lengthy, so I would anticipate it will begin at 10 a.m. We'll probably go into the early evening. They have scheduled tentatively several other board members' depositions and the retaking of former board member Wells' mediation, but we were able to get them to postpone those until after June the 20th, so that if we reach a resolution, there won't be a need for any more participation by the board. I am hopeful and feel relatively confident that we're going to reach a resolution and this thing will end on that day. If any of y'all have any individual questions, or if a board, if you want to meet in executive session at the June meeting prior to the mediation, we can. Our position and what they know going in is that we are not going to contribute anything financially. Their expectation from the Risk Management Trust and from us is that we're showing up as more observers, that there will be no requests entertained for any financial contribution. And with that being said, I want to also remind you that you have in Budget Code 141-35145 a designated amount that was set aside approximately 2 years ago on the anticipation that we weren't able to reach this resolution. I don't know how that has to be handled at the end of the year, because once the case is done, it's done, and that money's been designated and appropriated, and it's my feel that we're not going to have to spend any of it.
Jeff, you want to answer that? How do we need to handle it?
We'll carry the designation forward until such time that we know for an absolute fact, and then after that, in the next cycle forward, you could be free to do different things. But by keeping it designated, at least we have the money set aside, and we would be in a position to then decide.
And you would need to carry it at least 30 days forward from the date of mediation so that there could be no set aside or appeal. So that would in theory be July the 20th, which would get you into your next cycle. So that's good news. So number two and number three have to do with changes in the law that are relatively significant that affect you. One is very good. One is potentially extremely bad. The very good one is, as you know, there has been a lot of debate and amendment that's going back and forth with the teacher tenure law and how it's going to be affected by the acceptance of Tennessee of the Race to the Top money. Well, in its current form, and what I think that is going to be the approval is that your new teacher tenure law requires a 5-year apprenticeship process. The last 2 years of that process, the teacher will have to score 4s or 5s on their evaluations in order to be granted tenure. If they don't have 2 consecutive years, being years 4 and 5, then you can continue to hire them on a year-by-year basis as apprentice teachers, but you cannot tenure them until they have the 2 consecutive 4s or 5s. Any teacher that's already tenured in now, so the teachers that you currently have tenured are exempted from that requirement with one qualification. They have amended the law to allow for the dismissal of a tenured teacher under the grounds of failure to perform. This was a hotly debated topic. The unions across the state unilaterally were opposed to this, but now there is a provision where if a teacher fails to perform at the 4 or 5 level, the Board of Education has the ability, after you give the opportunity for the educator to remediate, they have to be given an opportunity after their evaluation process to remediate their performance. So I think that the meeting that I was at this past week says that if a teacher falls below a 4 or 5, a 1 or 2 or a 3, that the director of schools or that teacher supervisor that's charged with the evaluation would be required to provide them with a plan for remediation, essentially telling them what they need to do to correct their performance and give them some guidance and instruction what needs to be done. If the next year they do not bring their scores up to a 4 or 5, the Board of Education has the ability to revoke tenure. This is a significant change. It is going to require, obviously, the central office staff and your principals have to do multiple evaluations now. For a non-tenured teacher, it'll be 6 evaluations during the year. For a tenured teacher, it'll be 4. Those evaluations are a huge part of the performance. The test score, I think, will be about 1/3 of the overall performance, and then you'll have an evaluation component and then another component that gets to the 50%. Your principals will be evaluated on the test scores for everyone. 50% of the principal's evaluation on this 1 to 5 scale will additionally be part of the overall test scores. That segues into number 3, which is a bad change. that I think you all are going to have to begin to come up with a plan immediately to address. And to give you a little bit of background as to why your principal evaluation does not allow you the ability to exempt the special education scores. The teacher evaluations do. A special education student's test score will not be calculated into the raw test information that's used to come up with the teacher's evaluation. Not so for the school. In the state of Tennessee, you are allowed to exempt 2% of your special needs students. Okay, 1% of the special needs students that are your severely handicapped or disabled individuals, what you typically think of as a CDC student, can take a modified test. This is more of a sensory perception type of instrument. But that's only 1%. Most, and I don't know what your numbers are, in Anderson County, 17% of our students receive special education services. 2% of those students will be exempted and will be allowed to take the MOS test, which is a modified evaluation instrument, which has fewer choices and is easier for a child who's autistic or has learning disabilities to go. The remaining 15% are going to be tested on the regular ed curriculum. Here's what has occurred, that when the state of Tennessee jumped to take this race to the top money, they did not receive any input from the special education community and are just now faced with this problem. 2004, the federal government, as part of the No Child Left Behind statute, passed the 2004 amendment to the Individuals with Disabilities Education Act. It defined what services you have to provide your special needs students. Basically, it defined FAPE, which is free, appropriate public education. It said a school system, and in your all situation, since you are not the funding entity, this would include your county commission, because in Tennessee, for the most part, school districts do not fund. So your county commission is covered under what I'm getting ready to tell you as well. But FAPE, as of 2004, said a school system has to provide their special education component to those students receiving special education services an education plan, an individual education plan that will satisfy 3 curriculum. 1, it will allow that student to continue their education, meaning that they can graduate high school and be prepared to go to college if they so choose. Number 2, it will prepare the student for independent living, meaning that they have a physical disability that would prohibit them from independent living. We have to provide physical occupational speech therapy. And 3rd, it will prepare them to enter into the workplace. Nobody really thought about that because that was generally understood as to what FAPE required. 2007, the Supreme Court gave parents an individual cause of action that said you can now sue individual school systems and sue the county commissions if they are the funding entity if they don't provide FAPE services. Again, nobody really thought about that as being that big of a problem because at the time you were still dealing with No Child Left Behind. In December of 2009, for a decision that was published in February of 2010, Supreme Court delivered kind of a hammer blow that again would not have affected us but for Race to the Top when they came out and said we're going to take that a step farther. Now, even if a parent has a child that is not receiving special education services, let's say you have a child that has a minor speech impediment that would make them eligible for special ed services, but you didn't want that stigma attached and you never opted in to have your child receive those. If your child is otherwise eligible for special ed services, or if they are currently receiving special ed services, and the federal estimates are about 22 to 25% of all students would be eligible if they were tested, then you can sue the system if your child is not being provided a FAPE that would address those 3 concerns. Again, Tennessee got this information in and we thought, well, that's fine because most of our programs still do that. Well, when the state of Tennessee adopted the Race to the Top money, you were one of only 2 states to receive this federal funding, the $500 million. Tennessee chose to accept that money. Campbell County has accepted their portion of that money. You are now held to the new Race to the Top standards. The core curriculum standards that will go into place for the special needs students that will begin